have to construction period is more than 5 years, 10 years, 20 years, like that. So many based on the type of the project, period of the project will be depends. During the duration, disputes are arised. Disputes regarding for the successful completion of the project, we know the what are the type of which type of disputes arising from the industry. Those are discussed here. Mainly, the disputes are arised from waste of money, drain profits. They mainly depends upon the profit of the industry, destroy the relationship between and takes energy away from the projects. Those are the some disputes are discussed here. Construction delays, variations, efficiency issues, and exceeding costing can be some causes for the dispute to arise in the project. Typically, construction disputes occurs between the owner and the main contractor, subcontractors, subcontractors, and design professionals. For example, here we have to take one major project. It takes 10 years of project. In that scenario, we have to allocate the contract to the other people. So many people involved in the projects. Typically, construction disputes occurs between the owner and the main contractor, and contractor with the subcontractor, subcontractor with the subcontractor, and design professionals. Anybody they interact, they feel very low. In that scenario, we face the disputes in the construction. The main source of this problem is the lack of precision in the contract description between the involving the parties. The construction industry has tried a different way to avoid the disputes. Currently, construction industry uses building information modeling. So the main software in the construction is BIM software, 3D modeling, and it has significantly minimized these kinds of disputes. So in manpower, by using manpower for the construction, they arise one of the reason to cause the disputes. If we have to use the software, the disputes will be reduced. That's why we have to use the BM software in all the construction industries. They used BM software. The reasons for the construction disputes as being being a part of construction life fall into 4 categories: contract, finance, culture, and external factors. So disputes is a misunderstanding between two parties, either contractual or non-contractual, between the persons, is unable to eliminate because the nature of the construction is full risk. Thomas, they give a definition of the dispute. Thomas in 1995 they give one of the definition. Definition of the dispute may be circumcised, it may be inevitable, involve resolution of other matters which may not specifically have been raised into separate or discrete disputes. The judicial development of the definition of the disputes required to give an adjudicator threshold jurisdiction has been instrumental in encouraging the parties to exchange views and facts which support their case, but it can be rather blunt instrument for reducing the disputes and far short of pre-adjudication protocol. A dispute will not exist until a claim is asserted by one party which is disputed by the other party. So what are the factors of the disputes in the construction? We concentrated on the factors of the disputes. We eliminate the disputes in the construction. Terms of the contract. What are the terms and conditions are involved in the contract document? Technological issues. Which type of technology issues are raised? Project conditions. Parties involved, magnitude and site conditions, degree of bias, third party organizational behavior and culture. All those factors are involved in the disputes. Common causes of disputes: failure to properly administrate the contract, poorly drafted or incomplete unsubstantiated claims, employer, contractor, subcontractor failing to understand and or comply with its contractual obligation, errors and omissions in the contract document, incomplete design information or employer requirement, deficient management supervision. What are the causes of dispute by clients? deficient management supervision. So proper manpower is not provided, that causes the disputes in the construction. Lowest price mentality in engaging of the contractor. Some contractor they feel very low budget finishing the project. It is also one of the raising the dispute. Poor communication, discrepancies in contract documents, failure to appointment project management manager, one of the important parameter in the project manager. So project manager plays very important role in the construction. So project manager see the each and every element execution of the construction. So if absence of project manager, so contractor and manpower creates the disputes, failure to respond in time. So these are the causes of the disputes. Delay of the suspension of work. So proper completion of the project we didn't get in proper way. Lack of understanding and agreement in contract procurement. Inadequate CPN scheduling and update requirement. Failure to plan and execute the changes of the works. Reluctance to seek clarification. Failure to understand and correctly bid or price the works. Causes of construction disputes by the consultants. So in construction industry, so many people are involved, so many characteristics are played different roles. Failure to understand its responsibility under the design team contract. Some experienced people they feel very good knowledge and knowledge on the works and activities, but some illustrated people, some misbehaviour people they involve, those also in erases the disputes. Over design and understanding the cost involved. So main coordination between the designer, professionals and owner and contractor. So the major problem is the main thing is misunderstanding between all those roles of the people. Design and specification, oversight and errors, or omission from specialist, variations due to design errors, to request for information, late information delivery and cumbersome approach. Each and everything we have to see. Adjudication, it is a process in which a neutral third party will give a decision on a disputes. Construction and Regeneration Act 1996 states that parties to a construction contract may refer their disputes to an adjudicator. Adjudication has become known as a pay first, argue later way for the parties to resolve their disputes. Some companies they give some statement regarding initial payment, middle payment and final payment. There are three types of payments is there, but they have to say that pay first, argue later. So become known as like that. The legacy will be depends upon the company. So that is called adjudication. A successful party to adjudication can apply to the technology and construction court, then enforce an adjudicator decision. The decision of the adjudicator will be binding unless or until it is revised in arbitration or litigation. So the decision of the adjudicator will be binding unless or until it is revised to arbitration or litigation. Benefits of the adjudication: the adjudicator is a neutral person who is not involved in any day-to-day running of the contract, construction of the contract. So one legal person involved here. In behalf of that person, we have to obey the terms and conditions, and what are the works are allocated for the persons. Each and everything they have to discuss in the neutral person. That is called adjudication. Is a quick process which is designed to ensure that cash flow is maintained during the construction process. Although it is still possible to go to the court, in most cases the decision of the adjudicator decides the disputes. Adjudication is less expensive than court proceedings. What are the disadvantages of adjudication? The disputes needs to have arrayed between the parties before adjudication can be commenced. The adjudicator's powers are limited. Court proceedings are still required to enforce the adjudicator decision. losing party does not pay. So even adjudicator play one of the role, but in adjudicator as also having some terms and conditions. Based on that, they have to follow expected determination. It is often used to resolve issues or disputes of a specialist nature, such as construction, and is one of the most informal systems of dispute resolution. It is often used when there is a valuation disputes. If an expert is to be used to determine the disputes, the parties will agree this by contract and will agree that expert determination will be binding. Benefits of expert determination: it is an economic way of finally resolving valuation disputes, unless expensive and quicker and less formal method of dispute resolution. So it is one of the expert people involved in the disputes, reducing the disputes in the construction. The use of experts is much less tied to legal process, and therefore it is more difficult to challenge the decision of an expert. An expert's report cannot generally be enforced without further court and arbitration proceedings. Litigation: while there are many methods of ADR, court proceedings are still one of the most common forms of resolving disputes within the construction industry. The Technology and Construction Court is a specialist court which deals with technology and construction disputes and is governed not only by the civil procedure rules but also by the Technology and Construction Court Guide. The specialist TCC judge will deal with cases in the TCC. Technology and Construction Court is the major role play in the major construction in public, private, government construction activities. For example, tolls. Tolls is the one of the important project in the construction. So these are involved in the TCC, undergoing TCC. The specialist TCC judge will deal with cases in the TCC. Advantages of litigation: the claim process will be managed by the judge throughout. Complex issues can be dealt with. The parties will be obtained a binding and enforceable decision. Disadvantages of litigation: only claims which are over the value of 2,50,000 can be dealt with an TCC. Any claims below this sum will be dealt with at this country court. It is often a slow process and it is most expensive. The proceedings will be in a public and are therefore not confidentially expert in certain very limited circumstances. Mediation. So mediation is a commonly used within the construction industry to resolve disputes. The Technology and Construction Court Guide provides guidance on the conduct of litigation within the construction industry and states that courts should be encourage parties to use alternative disputes resolution, and which is most cases will be mediation. So the pre-action protocol for construction and engineering disputes requires parties in disputes to meet at least one before litigation commences to discuss the whatever some form of idea such as mediation would be more appreciate means to resolve disputes. So one of the benefits of mediation: a mediator will be an independent person who will not be make a decision, judge or advise. These people not involved in the construction activities but will facilitate discussion between the parties with the aim of resolving disputes. Mediators are generally highly experienced in the area of the disputes and may even TCC judges. It can help maintain a business relationship. It is relatively quick with mediations usually lasting 1 or 2 days. What are the benefits of mediation? It is usually considered less costly than litigation. Everything that happens in mediation is confidential. A mediator will encourage the parties to find a solution to dispute will suit both the parties' needs. What are the disadvantages? In some cases, there are maybe concern that during the mediation, parties may disclose an important aspect of their argument or commercial position. which confidential nature or mediation could benefit the other party if the matter went to trial. If the parties do not come to an agreement, the dispute will remain unresolved. The cost of the mediation will have been wasted. So arbitration. So discussed in next class. Thank